AP-77-105, Tyrone Jamaal Williams versus the State of Texas.
Chief Judge, Counsel, and may it please the Court. My name is Clay Thomas. I represent Tyrone Jamaal Williams in this matter. This is a capital murder case out of Hunt County in which Mr. Williams was convicted of murdering his wife and mother-in-law. He was subsequently sentenced to death, and it's for that reason we're here today. To start, I'd like to take you back just a bit in the fact that a few months back I was in the middle of a hearing on a capital case, and some newspaper reporter asked me, well, surely you believe in the death penalty, don't believe in the death penalty. And I said, well, no, you're wrong. Actually, I do believe in it. I just think you've got to get there the right way. And largely that's what we are here for today. We have roughly three issues here. One of them, of course, is the prohibition of jurors with complaints against the death penalty of being kept silent. I think it is a well-worn path, but probably not well-worn this way. It seems to me that a juror is nothing more than a voter, and a voter is going to have some opinion in the community standards to which that community ought to apply the law. Now, granted, one can certainly say that, and I think this is the way the law basically holds it, is that we want you to apply the law, but we want to apply the law in the way that we say, not in the way that you believe.
Okay.
Well, for instance, if you look at that, Texas is a representative republic. It is not a democracy. Okay, and so when was the last time the death penalty was actually brought for a popular vote? I don't know. I do know that the legislature brought it back at the end of 1972. But certainly in 52 years, community standards must have changed. Now, if what we tell individuals that are sitting for a jury is that we respect your religion, but that doesn't work, and you have an issue with which you disagree with the death penalty, why is it that you should be allowed to serve? Well, again, the right to serve on a jury is much akin to the right to vote, because that jury does make votes. And it seems to me that when we look at that from that perspective, we have to take into concern those community standards. Now,
Do you have some specific complaints about some specific jurors and how they were dealt with?
I do. In this case, for instance, we have Ms. Burton who said, well, if something personally happened to someone in my family, like my child, for instance, I may feel like I would want it to happen. But at the Batson hearing, the state said she did say she strongly supports or would support life without parole. That's not abhorrent. Mr. Henry, I oppose the death penalty. I do not believe the state should be in the business of ending an individual's life. I didn't believe my personal bias would impact me from being able to serve on the jury. But Mr. Lilley said that the philosophical opposition was enough. Mr. Singleton also said he felt this was God's province, take a life. Now, the larger votes are, of course, or the larger issues have been in the past has been the issue of religion. But the fact of the matter is that this hasn't even been put before a popular vote in at least 52 years. And it seems to me that when we're concerned about community standards, that should say something, okay? Our community standards have a tendency, I believe, to evolve over a period of time. And it should be the jury that gets to decide those, not the legislature and not the court.
Are you advancing the argument that the courts should allow people who have an objection to the death penalty in general to serve on a death case, on a case in which the law permits the imposition of the death penalty?
I am, and here's why. When we think of the reason to take someone's life, the reason should be so great and so egregious that what ought to happen here is that even that person that says, I just don't feel good about doing it, would do it anyway. Because it's soul shaking. As opposed to just saying, we've got an issue here where the law says if you have an objection, you can't serve.
Do you have any objection to the rule that would say that before a person is qualified to serve on a jury, that they be somebody who is capable of following the law that will be given to them by the court?
I do not. I have an objection to the fact that they get asked about it. Okay? And please understand, death penalty cases are extraordinary matters. They are not like everything else. For instance, if I were to step back and say, okay, you've got a sentence from 2 to 20, okay? If you have a sentence from 2 to 20, then what you wind up having is an issue where you would have to ask the juror, okay, can you go with 20? Can you go with probation? We've all been through this. We know this, okay? But death is different. Death is the finality. There is no hope past that. There is no life past that. And that's where I've got an issue with it. It ought to be that when someone gets their lives snuffed out, whether it is by lethal injection or, as we're hearing lately, firing squads, electrocution, doesn't really matter. The reality here is that what ought to occur is that there is a visceral feeling. Now, I'm not saying that the jury couldn't get to this point. In many cases, they can, even if they have an absolute thing of, my God, I just going in, I can't do it. But that is what trials are about.
So you're saying that because death is different, people should not have to follow the law in death cases? That's what I think I'm hearing you say, but in other cases, non-death cases, people should, hopefully, you would believe jurors still have to follow the law? I mean, I'm having a hard time following.
I understand.
You're asking us to say jurors don't have to follow the law.
Is that right?
Am I right about that?
Well, the way you're thinking is correct. However, maybe not so correct. And the way in which I would say it's not correct is that there is I just think the law is wrong. Let's face it. I mean, the reality here is that you're saying we've got a certain attitude or certain place we want to get, okay? When we talk about justice, we talk about an unbiased justice, correct? Both sides are on even keel, correct?
Including unbiased not biased against the law, right? Against the actual law that the legislature passed.
Right. So what I'm saying is if you hold that bias against a juror or a potential juror, do you not also hold that same bias against the defense? I mean, you can't go one or the other. The reality here is that this is not something that really ought to be a matter of a subject.
Well, counsel, following on what Judge Erie said, I mean, you're certainly aware that there are groups in this country that want to completely end prisons, and so would we hold it to that? Would we hold those potential jurors to the same standard? Like, it's a burglary case, and they say, well, I just don't even believe in prison, and the defendant's not probation eligible. I mean, surely you wouldn't say that we have to put those people on a jury, would you? Or would you? I guess I shouldn't put words in your mouth.
I think death is a special case. I do. And yes, there's certainly very, for instance, Florida, now you need 4 for the death penalty. Georgia, no, I'm sorry, Alabama, I believe you need 2, or 10 rather. So, and actually I meant 8 for Florida. So in Florida and Georgia, they've actually made it even less. So they've actually changed the playing field. At least here, we're somewhat unanimous. But that does not get us past the point of saying, is it proper to have a law which actually states that you must be willing to give that ultimate sanction, even if you don't agree. And if you don't agree, by the way, you can't participate.
Am I correct that you are posing this as a right of the jurors to serve?
Yes, Your Honor.
Counsel, since this was mentioned, I would like to go back to something you said. You said that we do have, as citizens, a right to serve on the jury.
That is correct.
Where does that right come from? I have not read that anywhere, as far as
Well,
I know.
I would see that's an extension of the First Amendment.
Is it not analogous to the Batson holding?
I'm sorry?
Isn't your argument analogous to the holding in Batson, that the jurors have a right to serve?
That's correct.
Okay.
And I see my time is almost up.
Did you reserve time for?
I did.
Okay, thank you, counsel.
Good morning, Presiding Judge Keller and members of the Court of Criminal Appeals. My name is Steve Lilley, and I represent Hunt County in this case. The first issue, which was the issue that was brought up by the appellant here just now, is, I think, more accurately stated, is whether the state unconstitutionally challenged for cause and used peremptory strikes against potential jurors who have personal scruples of varying degree against the death penalty. 3 of the 4 jurors that were excluded from service were, the state used peremptory strikes against. One of them was a challenge for cause. And it's important to note, first of all, that their opinions against the death penalty was a primary reason stated by the state, in fact myself, as the reason why we were using a peremptory strike against them. And that was not something...
Is there a challenge made on those 3 for cause, and was that denied, and then you had to use your peremptories?
For one of them, from my memory and based on my review before today, one of them we did attempt to use a challenge for cause, and that was denied. And then we used a peremptory strike. That was juror number 17, but my memory serves. Juror number 113, we used a challenge for cause. It was granted. The other 2 were peremptory strikes initially, because the state did say, I don't believe that this juror has said something that will rise to the level of a challenge for cause. We nevertheless find them to be unacceptable to the state. So what the point of that is, though, is that there was no objection at the trial court level on this ground. And so I think the more fundamental issue, or one fundamental issue, is whether or not this error was even preserved for appeal. There were objections based on Batson on 2 of them, but the other ones there was not. So there was no objection at the trial court level based on the ground that the appellant brings forward today. And it is important to note that, Presiding Judge Keller, you mentioned the Batson issue as being, or this being analogous to Batson. It is, but it isn't. Of course, Batson deals with the right to be free from racial and gender discrimination in the jury selection process, having the ability to serve on a jury. But there is no, to the point that was made earlier by Judge Walker, there is no fundamental right for service on a particular jury, and that is different from the right to vote. Now, the appellant tries to conflate the two in his brief and in his argument, but the two are very different. The right to vote is a fundamental right recognized by the Supreme Court and other courts, but the right to serve on a particular jury is not, and that just makes sense.
Can I get back here? You mentioned
Yes.
something about the objection being made. So was there no objection made at the time of jury selection that this person is being excluded based on some First Amendment right to serve on the jury, or was it just based on race or gender?
For the two Batson challenges, it was based on race, and I believe one of them was female, so you can see that as being both. But no, not on this ground.
So the state wasn't put on any kind of notice that the defense objected to jurors being excluded because of their belief or non-belief in the death penalty?
No, Your Honor, they were not. And I believe there may have been, I don't want to misstate the fact there may have been some global motion filed before jury selection started, but as far as these particular, I don't recall that, but I don't want to say affirmatively that there was not. But as far as these particular jurors, no, there was not. I do know that that opposing counsel, the appellant, did identify three potential issues that they wanted to argue before the court, and I'm assuming that one or two of those will be talked about in his rebuttal time. So I don't want to, I do want to address those with the idea that they might be addressed later. And I think maybe it would be best to start or to move to the fourth issue, and that is whether or not the trial court committed error in refusing to admit 79 pages of deposition testimony that was admitted as testimony of a witness who wasn't available to be there during the punishment phase of the proceedings. This was the appellant's grandmother who the parties went down to Beaumont to talk with and do a deposition of. And when it came time for trial, the appellant attempted to admit the entire deposition testimony for the jury to consider, but the state objected to about half of it. And the court reviewed it and determined that about half of it, 79 pages or so, was irrelevant to the issues pertaining to punishment in this proceeding. And therefore, the trial court decided it was not going to be permitted, it wasn't going to be admitted. Now, that was obviously I don't want to say obviously, but it was something that was preserved for appeal, and I did want to address it, and that is that there are two standards by which we can look at whether or not, or what type of evidence is admissible in the punishment proceeding in a death penalty case. So this state talks, the Code of Criminal Procedure, Article 37071A1, it talks about the evidence of defendant's background or character is the limit, I guess, is specifically by statute relevant in the punishment proceeding in a death penalty case. Now that is a broad, and it should be, that is a broad category of evidence, but it's not unlimited. It talks about, the statute specifically says, the defendant's background or character. And what these first 79 pages dealt with were the defendant's grandmother's family history, and it was a compelling and a very sad history, but it was not the defendant's.
Did the defendant live with the grandmother or view this abuse or anything like that?
No, not the grandmother. No, not in any extent that I'm aware of. Judge, thank you for asking. I think that there may have been a time where he did live with his grandmother later on and then lived with his mother. I don't recall that specifically, but the point of, and that was likely covered in the last 77 pages that was admitted, because it wasn't the entire testimony that was thrown out. I don't want to say thrown out, but not admitted. It was the first part, which dealt specifically with the grandmother's raising, the grandmother's tragic upbringing, that all dealt with stuff before he was born. And so the trial court correctly parsed that out and saying that these first 79 pages plus deal with tragic circumstances that don't have anything to do with the defendant. He wasn't even born yet. In fact, his mother is only mentioned one time in the first 79 pages of that trial, that deposition. But after she comes into the picture, the trial court decided that was relevant, and the court was allowed to consider it. And so we believe this was a proper ruling under Article 3707(1), and this court has said that the testimony has to have a more than tenuous connection to the defendant's moral culpability, and it just strains strains credulity to say that the grandmother's upbringing before he was born has anything to do with the defendant's upbringing or the defendant's moral culpability. And he was not born, he was not aware of this, maybe he was told later, but it doesn't have anything to do with him. And so we believe that was the proper ruling by the trial court, and it fits well under this, under the statutory and the case law for what is allowed to be brought in during the punishment phase of a death penalty proceeding. So that is the standard there. The court didn't commit any error. And the state's position is if this court decided there was some error, that maybe there was some tenuous relevance to that information, that therefore, if we assume error or we find error, then it still was not harmful, because the trial court admitted the other part of that proceeding, of that deposition testimony. The defense still got to call, I believe it was 17 or 18 witnesses during the punishment proceeding, including numerous experts and scientific evidence of the defendant's brain structure, function, and things like that, and all kinds of other witnesses. So the defense still got to put on a robust, very robust punishment case. And we're talking about one part of one witness in that proceeding. And therefore, we believe that based on that and the state's very compelling evidence in guilt, innocence, and some of the other evidence the state put on during punishment, that there was no harm here. If there was error, which we don't concede and don't believe there was, but even if there was no harm that can be found here. This court can be comfortable and satisfied beyond a reasonable doubt that this had very marginal weight because it didn't have anything to do with the defendant when he was alive. And the evidence was so compelling that the state put on of the very brutal nature of this double homicide. And so that is our position on issue number 4. I do want to talk a little bit about issue number 2 and I want to talk a little bit about issue number 2. This one is a little bit harder to narrow down what the exact issue is. It was litigated at the trial court level, but on appeal, appellant makes 2 arguments, and that is, one, that the indictment should have been dismissed based on an alleged intrusion into the defendant's Sixth Amendment right to a fair jury trial, to a fair trial, because of intrusions into his attorney-client privilege. That is one argument that he makes. The second argument that he makes is that the district attorney's office in Hunt County should have been disqualified from, depending on how you read the argument and also what happened at trial, whether it's a limited recusal or disqualification for purposes only of hearing this motion to dismiss, or if it's the whole thing. Now, at the trial court level, it was very clear that the defense was only seeking to disqualify the office for this motion to dismiss. Now, the appellant on appeal raises a more global disqualification argument. That was not preserved for this court to review. It was an intentional decision by the defense.
Excuse me.
Very strange.
Yeah.
How far back do I need to go? I have sympathy. I run the soundboard for church. I know how that goes.
Why don't you turn it off?
Okay, I
Yeah.
can project.
Thank you.
Taught me that in law school.
I can hear you fine.
Okay.
Okay.
All right.
Was there an actual hearing to disqualify the DA's office?
For the limited, yes, there was a hearing. For the limited purpose of the motion to dismiss, there was a hearing, and then there was a subsequent hearing on the motion to dismiss. I'm sorry, Judge, I can't remember which one you asked about just now. But the
Okay.
disqualification, yes, there was, and there was a further hearing with testimony by about a motion to dismiss. So there was both, and it was a contested issue, but there was a very intentional choice by the defense not to seek disqualification for the entire case. And it's obvious because that's what they filed. They filed a limited recusal motion or disqualification motion. Now, the appellant raises on appeal that it should have been a total disqualification. That's not what was requested at the trial court level. Therefore, that was not reserved for this court to consider. That is our base argument there. And of course, we can talk about the motion to dismiss the indictment, and I think that should be issued. The trial court, obviously, the state's position is that if there is an intrusion at all in this case, and we do not concede that there was, that it did not rise anywhere close to the standard that's required to dismiss an indictment, never to be refiled, basically, with prejudice. That did not happen here. What happened here does not rise to the level that this court found in the Fry case, I think that was in 1995, or any other case, the Morrison case, which the Supreme Court was talking about. That's where we have these rules and these ideas about when dismissal is appropriate. That's not what happened here. The Fry case, if we're comparing it, involves a district attorney's office literally calling a defendant who didn't have an active indictment at the time and trying to talk to him when they knew, because he told them that he was represented by counsel or had an attorney, and they continued to speak with him about his side of the story and later filed an indictment.
So how do you classify what happened with the observation of the jail logs?
How do I classify it as?
Well, the defense classifies it as an illegal act and, of course, an intrusion on the attorney-client privilege.
Yes, absolutely. Well, I can classify by what it's not. It was not illegal because there's no statute that was violated. So it is not illegal in any sense. No federal or state statute violated.
Court didn't issue an order? The court didn't issue an order?
The court did issue an order, but I don't define that as being an illegal act. I think the court has the legal authority, of course. What I believe happened here was I struggle to come up with the words for it, but at most it was the jail, the Hunt County Detention Center, either on accident violating a court order to not make that information available to anybody else.
Did you ask to see it, or did they just give it to you?
No, neither of those things. In Hunt County and in a lot of counties, we have a unified software system. Now, there's a side for the prosecutor's offices, there's a side for the district clerk, and there's a side for jail information. And in the jail, we have access to almost all of those realms. We have the access that's granted to us, and including jail information. We can look up biographical information on a defendant, we can look up documents filed since he's been in jail, if there's been grievances filed, if there's been complaints filed, if there's been disciplinary action filed. And one of the things that is available to those who have access is contacts while they're in jail. And it just produces a list on the computer of the people that have visited a defendant. And that's where that information comes from. The state did not request that information, especially in this case. They did not surreptitiously provide it to us without us asking. It's just there. And so I think that at most what we have is a misunderstanding about when somebody asks for this, you cannot provide it. And the defense was upset that there was not some block put on it that made it so it was not illegal by anybody else. That would seem to be their complaint.
Was the order delivered to the jail? Did the jail have any, the people who would input that information into the database?
Yes.
Were they given notice that there was an order in the trial court?
The record indicates that they were given that order. Yes, Judge. They were given that order, and that. But that is an important consideration. But it is not ultimately decisive on the issue of whether or not the Sixth Amendment rights were intruded upon. Was it a mistake that was made by them? Yes, it was. Was it something that resulted in a Sixth Amendment violation, resulting in probable dismissal of the indictment? Clearly not, because the information that the
it could reveal, for example, a strategy. If you knew what kind of medical professionals, for example, had showed up to interview the defense's client, then you might discern from that they might be advancing towards a certain kind of defense because of the type of doctor that was coming to see them. So, I mean, there is that, right? You would acknowledge that.
Yes, Judge Erie, I would acknowledge that, and in the proper case, perhaps that would be something that would lead to some sort of sanction, be it limitations on cross-examination or some other sanction short of dismissal of the indictment. But in this particular case, the issues and talk between, and the record is clear on this, I believe as well, is that the questions of whether or not the defense was going to include some issues regarding his mental health or his stability in that regard, there was no question that that was going to be something that the defense was going to bring up. It had been talked about between the parties informally before that for months. And so...
And that's in the record.
There's record of us having conversations. Well, we talked about it during the hearing, yes.
I mean, I want to make sure that you're not giving us just your personal recollection
Yeah, that is
versus what we can see in the record, yeah.
The record does reflect that there were during the hearing, there is testimony from myself that there was conversations about there being mental health issues and conversations about their clients. That is talked about in the record. And even, Judge Erie, the question is well taken about the potential strategy. The court in Morrison, the Supreme Court in Morrison does say that if the state learned the details of a defendant's trial strategy, that perhaps that would lead to some sort of sanction that might be appropriate. But that's not what happened here. Even if we take everything that happened, the Supreme Court said that one of the ways is to learn the details of the trial strategy, and that is not what happened here. What happened here is learning names, and then when those names were made, when it was made clear that those were mental health professionals. Again, there was no indication in the jail record that those were defense experts. But when it became clear that they were mental health professionals, no further work was done on it. And those are not, even on the outside realm, cannot say that those are details of trial strategy. See that my time is up, and now timer's counting up. So thank you very much for your time. Unless there are any other questions.
Thank you, counsel.
Thank you.
My friend here stated that no harm was done by the surreptitious discovery of these individuals. And in fact, the only party that said that there was any discussion about mental health was Mr. Lilley. So, and that is in the record, sir. But he is the only one, to my knowledge.
Anyone say from the defense side, oh, that's not true, Your Honor? Anybody say that to contradict the claim that was being made on the record?
I believe they did. I believe what they did do was to say, we do not have anything specifically to talk about. And let's face it, LeBron requires specificity. And that was not here. Mr. Lilley was asked, when you discovered the potential expert witnesses that may have been procured by the defense via an ex parte confidential concealed order, did you notify anybody that the name of these names were on the list? No. Did you do anything about it later on to rectify it? No. Did you tell defense counsel that you know about it? Well, I did when I filed the motion. In fact, his closing argument on that hearing is very, very revealing. He says, what happened here is the state wanted to file something, they knew they should probably get around to filing it, and to wait until they, the defense, had to disclose their experts in a case where everybody knew that there were experts all over the place. There's no secret about that. Really? should have put in Christmas, maybe right after Christmas, for us to only then file the groan motion. In the real world, courtroom and capital litigation, that just doesn't make any sense, Your Honor.
Can you maybe give us your articulation of how this discovery by the prosecution harmed your case?
Certainly. The main thing I can think about is this. From everything that I've been able to tell about the case, Mr. Williams is a little bit married, and he is non-trusting. And if he cannot trust that the things that he believes are going to be kept confidential, why would he trust anyone? The court should note, and it's not here in the brief, of course, but after the hearing, Mr. Williams immediately made an accusation against one of his counsel. And I believe, in my mind, that had to do with some of the lack of faith in the confidentiality that was getting accomplished here. That's problematic. Counsel must be able to communicate straightforwardly, honestly, and confidentially with their clients. If not, there is no reason whatever for us to have it. Which was premature, as they have mentioned. So now we find out, by the filing of a motion, that there's a violation. We find out that, okay, now the court has said, well, no harm, no foul. If there's no harm, no foul, then why would I want to talk to anyone else? Why would I? And in fact, in the trial, Mr. Williams says, I want to testify because I really haven't had any ability to talk to my lawyers. And I don't think he meant that they don't come by and see me. I believe it had to do more with the fact that he just did not feel that what he was getting was entirely confidential. That confidentiality matters. It suppresses, the lack of it suppresses all of it.
But there was no disclosure of what any of these people said to either the lawyers or the defendant.
I think
just names.
That's true.
And eventually the names of the experts would have to be disclosed anyway.
They would. However, I'm saying that this had a chilling effect on the defendant. Okay? Defendants have a tendency, and I know all of you know this, they have a tendency to come back and they've got to say, look, whatever I tell you and whatever we discuss, and the people that I send to you, or that come to see me, at least until the proper time, needs to be kept in secret. As defense attorneys, we do this all the time. We ask for ex parte orders. There's a reason for that. We don't want the other side to know what our thought process may or may not be. And the violation of that is also a violation of the attorney work privilege. Okay? And that's where that piece goes. Now, if I may, because I've got so little time left, what I would like to mention here is when we come back to the deposition, they state that these things are not, that 78 or 79 pages was really immaterial. It seems to me that when a court says, well, I don't, here it is. The court stated, for instance, Ms. Smith describes in some detail the windows of her house being pushed in by an intruder who came to the house when her mother was not there, raped her, got her pregnant, and those kind of things, but you can't draw any conclusion about the defendant's upbringing from that experience. Are we serious? Did we all grow up in a vacuum? Are we not our grandparents' grandchildren? There are untold amounts of subliminal issues that occur. And therefore, as far as I'm concerned, I believe that it should have been heard, because that has something to do with the way the family develops overall.
Was there any evidence that any of that affected the development of this defendant's family?
We never got to it. I believe that when you're raised in kind of an atmosphere of that kind of violence, I think that's entirely possible.
But didn't most of this happen before he was even born?
I don't think that matters. And
Well,
the reason I say that, Your Honor, is this. None of us, again, were born in a vacuum.
But we
Yes.
wouldn't want to hear, somebody get up and testify in the middle of a trial about a particular defendant's actions about, for example, the dropping of the atomic bomb on Hiroshima. But it has an impact because after all, there are atomic bombs and people have used them. Not only that, it was the U.S. At a certain point, you're so, and I don't mean to prolong it, but it's so far removed from this defendant's actions and his own personal moral culpability that, well, go ahead, respond to that.
Well, Your Honor, I would agree that it is far removed, but I'm not sure removed enough, okay? A violent rape is a problem. For myself personally, I represented someone who, in a capital case, whose mother was violently raped in front of him at the age of 5. And he was mentally ill from that day on. So
But that's very different from what you're describing.
it is, except for the fact that you have these things and you have these attitudes that people grow up with. I don't think there's any excuse for what happens, but I think that we need to at least get a good grip on what that family was like. And as I see my time's up, is there anything?
Thank you, counsel.
Thank you.
The case is submitted. Let's give a minute, try and get this fixed.
So we just take a 5-minute break.
She said no. Oh,
And I'll take my-
Sharon.
Okay, the court will stand in recess for 5 minutes.